Yasis Alayich. That's taken from Lecha Dodi, the Friday night song. Very apt for tonight's daf. It's the line means that God shall rejoice over his people the way a bridegroom rejoices over his bride. How's everybody doing? It's great to be with you on a Tuesday. Let's light up the darkness. Who is with us to do some beautiful learning here in Tractate Yevamos, the 14th volume of the Talmud? Melissa in Great Neck, David in New York, Shandor in the Bronx, Yehud in South Carolina, Paula in Chicago, Guy in Ohio, Bill in Mid-Missouri, Maggie in Miami, Bella in Florida, Lucy in Minnesota, Franco in Trieste from across the pond. Welcome. Wait, skipped on me. Barbara in Arkansas, David in Indiana, Joseph in Massachusetts, Dawn, excuse me, checking in, Jay in Missouri, Stephen in New Hampshire, Paula in the Great Northwest, James in Indianapolis, over there on the YouTube side, Michelle in Washington State, Marjorie in Georgia, Lynn in North Texas, Aoife in Florida. Welcome, everybody. Tonight's daf is Kuf Yud Gimel, page 113, here in chapter 14 of the 14th volume of the Talmud. These are the laws of levirate marriage. We're really getting close to the end. The tractate ends on page 122. We are discussing Mishna number 1 here in tractate 14. And this Mishna was a rather lengthy Mishna, which laid out a whole bunch of different cases involving two brothers, one of whom was legally competent, the other was a deaf mute, and thus legally not competent in the ancient world. Or both were legally competent, but one is married to a legally competent woman and the other is married to a deaf mute, or both are married to deaf mutes, or they're married to sisters, etc. And if one of them dies, then how do we handle the yibum situation when a man dies childless, leaving a brother and a widow? So they should perform yibum. They should marry, and their first child will be considered the heir of the man who died. Or they perform the alternative mitzvah, the ceremony of chalitza, which releases them from that obligation, and she's free to go marry whoever she wants. Excuse me. But when there's somebody, who is a deaf mute, so then under ancient law, they're legally not competent to enter into contracts, and that's going to have an impact. A deaf mute cannot perform chalitza, not because of legal competence, but because she cannot speak the verses which need to be spoken in the chalitza ceremony. Or if he is a deaf mute, and there's going to be a situation where the only option is to marry and divorce, it's a problem because he can't, as a deaf mute, give a bill of divorce. A marriage to a deaf mute is a real marriage, but is recognized by rabbinic law as opposed to Torah law. So these were some of the nuances that came up in the Mishnah yesterday. Now we begin the Gemara, the discussion about that Mishnah. Wow, I was on the road all day. Nina and I were doing a location scout for our upcoming movie, Guns and Moses. It's coming along great. We're really getting excited. It's a lot of fun. Okay, the Gemara. Rami Bar Chama said, what is the difference between the case of a deaf-mute man and a deaf-mute woman, such that the sages enacted rabbinic marriage for them despite their condition, compared to the case of an imbecile man or an imbecile woman? Now here the word imbecile means somebody who is just, has the mental age of a small child and just can never enter into a legal contract because they would get taken advantage of. Right? So legally speaking, a deaf mute is not legally competent, even though they might have complete faculties. But an imbecile, also legally not competent, and we know does not have the mental faculty. So what is the difference between them legally speaking? Asked Rami Bar Chama. that the deaf-mute man and woman, for them the sages enacted marriage by rabbinic law despite their condition, but for the imbecile man or the imbecile woman, the sages did not enact marriage for them. What's the answer? As it is taught in a Baraisa, with regard to an imbecile man and a minor who married women and died, their wives are exempt from chalitza and from yibum, because that marriage was never a marriage at all, even by rabbinic law. This indicates that the marriages of an imbecile and a minor are of no significance. So the Gemara explains, in the case of a deaf-mute man and a deaf-mute woman, where the ordinance, the decree of the sages can be fulfilled, i.e., these marriages can be maintained. So then the sages enacted marriage for them. By contrast, with regard to an imbecile man or an imbecile woman, where the decree of the sages cannot be fulfilled, as one cannot live with an imbecile partner in accordance with the well-known saying, a person cannot reside in a basket, i.e. in close quarters with a snake. And for them, the sages did not enact marriage for them. Now, an imbecile is not like a snake. It's not that there's something evil about them. But you can't have a marriage on anything like equal terms, right? So even though the deaf-mute doesn't have legal competency in most situations to enter into contracts, because we're not sure if they understood what the terms of the contract are, again, in ancient times, the imbecile for sure did not understand and for sure cannot be a partner in marriage. So the sages did not decree. Now, is it possible that somebody might choose to be married to an imbecile anyway? Well, they might make that choice, but the sages are saying you should not make that choice because that cannot be a real marriage. So the Gemara asks, and what is the difference between a minor that the sages did not enact marriage for him and a deaf-mute that the sages did enact marriage for him, right? A minor also lacks legal competency. So the Gemara explains, in the case of a deaf-mute, as he will not reach the stage of eligibility for marriage by Torah law, the sages enacted marriage for him. But with regard to a minor, well, eventually he'll become an adult, and then he will be eligible for full marriage by Torah law. So the sages did not enact marriage by rabbinic decree for him. So the Gemara raises a difficulty. But there is the case of a minor girl who will reach the stage of eligibility for marriage by Torah law someday, and yet the sages enacted marriage for her, as her mother and brothers may marry her off by rabbinic law. So the Gemara answers, there the sages issued their decree for a different reason, so that people should not treat her in the manner of ownerless property. If she marries, her husband will watch over her. If not, she might be treated disrespectfully. So they enacted marriage for her by rabbinic law. So the Gemara asks, what is the difference between a minor girl? And by the way, we've been at the bottom of page 112b, and we're about to come to the top of page 113a. So what is the difference between a minor girl that she may perform refusal, i.e. she can retroactively nullify her marriage by means of a declaration of refusal of her husband? What's the difference between her and a female deaf-mute? The female deaf-mute cannot perform refusal, as the sages did not establish the option of making a declaration of refusal in the case of a female deaf-mute. Since the marriage of a deaf-mute woman also applies by rabbinic law, why didn't the sages establish refusal in her case as well? And the Gemara answers, the reason is that if so, i.e. had the sages enacted refusal for a female deaf-mute, others would refrain from marrying her at all, as she can issue a declaration of refusal at any time indefinitely. A minor girl who's married by rabbinic law, she can only issue that refusal until she becomes an adult woman. Then the only way out of the marriage is through divorce. So if you gave a deaf-mute adult woman the right of refusal, she would retain that right indefinitely. If she lived, for another 60 years, at any moment, she could walk away from the marriage. And then that might discourage a husband from marrying her. And therefore, to sort of prevent that from happening, the sages didn't issue that right of refusal to the female deaf-mute. Now we're on 113a. The Gemara further asks, what is the difference between a minor girl that she may partake of teruma when she is married to a priest, right? So if the daughter of an Israelite marries a priest, once she leaves her father's house and is now married to the priest and living in his house, she eats of his teruma, right? Teruma is food that's consecrated for priests. A regular Jew, a child of Israel, a Jew, cannot eat teruma. Only a priest, right? Only a Kohen can eat teruma. But a priest can share his teruma with the other members of his household, his wife and his children. So once she becomes his wife, she can start eating teruma, even though when she lived in her father's house, she could not. A minor girl who is married to a priest also may eat his teruma. Now, if you say that a minor girl, her marriage to an adult Jewish man is only by rabbinic law and not by Torah law because she's a minor, perhaps we should say that she should not eat teruma until she becomes his adult wife. So what is the difference between a minor girl that she may partake of teruma when she's married to a priest and a deaf-mute woman that she may not partake of teruma when she is married to a priest, despite the fact that both of their marriages apply by rabbinic law? That's a surprise. You would have thought that the deaf-mute woman, who might spend, decades, many decades, as the wife of this priest, that she would be allowed to partake of teruma. But because her marriage is only by rabbinic law, they don't allow her to partake of teruma. So now we're really surprised that so the difference is a marriage by rabbinic law to a priest does not entitle the wife to eat teruma. Why does the minor girl, who's also married by rabbinic law, why is she in fact allowed to eat teruma in his house? And the answer is, as we learned in a Mishna in Tractate Gittin on page 55b, Rabbi Yochanan ben Gudgada testified with regard to a female deaf-mute whose father married her off that she can be divorced with a bill of divorce. And he testified with regard to a minor girl, the daughter of a non-priest who was married to a priest, that she may partake of teruma, whereas a deaf-mute woman, it may be inferred, may not partake of teruma. And so the Gemara answers, the reason that a deaf-mute woman may not partake of teruma, even if she is married to a halakhically competent priest, is due to a rabbinic decree, lest a deaf-mute priest likewise feed teruma to his deaf-mute wife. And the Gemara asks, and which prohibition would that violate? Let him feed her, as he is equivalent to a minor who eats meat from unslaughtered animals. So eating meat from unslaughtered animals, that's eating treif. That's what treif actually is. Sometimes we use treif to mean non-kosher food, but specifically what it means is that when you eat meat from an animal that was not shechted, not slaughtered in a kosher manner. If a child does that, it's not the same transgression as an adult Jew. So why not let this deaf-mute priest feed teruma to his deaf-mute wife? Where am I? Like unslaughtered animals. So this is referring to the law that there is no obligation to prevent minors from committing transgressions. We educate them not to commit transgressions, but we don't violate a commandment when they make a mistake, and it's on our watch. So since a deaf-mute who is not legally competent has the status of a minor for certain laws, so then the same reasoning should apply in this case. Consequently, the court should be under no obligation to prevent this deaf-mute woman from eating teruma in her priest's husband's house. So rather, the reason we don't let her is that it's a rabbinic decree lest a deaf-mute priest feed teruma to his halachically competent wife. If a deaf-mute priest, because he's a priest, he can eat teruma, but he can't feed teruma to members of his house, I guess because his marriage is only a marriage by rabbinic law and not by Torah law. So even if he marries a legally competent woman, she can enter that marriage fully, but he can't. And so that's why we don't want him to feed her teruma. And the Gemara asks, well, in that case too, in the case of a deaf-mute priest who wishes to feed his legally competent wife teruma, let her partake of teruma. That applies by rabbinic law, because there's teruma by Torah law and teruma by rabbinic law. So maybe we should allow him to feed her teruma that is teruma by rabbinic law. What does that mean? There are types of produce from which there is no obligation to separate teruma by Torah law, but one does separate teruma from them due to a rabbinic decree. I believe, I'm just recalling here, that for instance, if you grow produce in a pot, you don't have to, you only separate teruma from produce that comes out of the ground, right? On your farm, you separate the first 2% to give to a priest as the priestly tithe. But if you grow that produce in a pot, then we don't tithe it, but by Torah law. But by rabbinic decree, I think they did issue a decree that you would tithe it, lest people who grow a lot of produce, in their, city farms, their city gardens, in pots, come to think that we have gotten rid of the obligation to tithe teruma. The sages decreed that you do tithe from produce grown in a pot. I might be wrong about that, but I'm pretty sure it's that kind of example. And so, since that kind of teruma is teruma by rabbinic decree rather than by Torah law, let this deaf-mute priest married to a legally competent woman who doesn't have an obligation, who cannot feed her teruma according to Torah law, let him feed her this teruma by rabbinic law. So she should be permitted to eat that. And the Gemara answers, it is a rabbinic decree that we don't allow this, that the deaf-mute priest should give teruma to his legally competent wife. We don't allow it because perhaps he will come to feed her teruma that does apply by Torah law, right? So it's the fence around the Torah concept. So the Gemara further asks, and what is the difference between a minor girl that she has a marriage contract, a ketubah, and a deaf-mute woman that she does not have a marriage contract? So the Gemara answers, the reason is that if the husband of a deaf-mute would be obligated to give her a marriage contract, men would refrain from marrying her at all. It was very difficult for a deaf-mute woman to find a husband, so they didn't want to put up many barriers for her to find one. And the Gemara asks, and a minor girl, from where do we derive that she does have a marriage contract? As we learned in a Mishna at Bava Metzia 67a, with regard to a minor who refuses her husband and leaves him, and likewise a woman who is a secondary forbidden relative who's prohibited by rabbinic law, not a close relative like a sister or a mother, but a further off relative like an aunt. So she's a secondary forbidden relative who's prohibited by rabbinic law, and a sexually underdeveloped woman, an Elonis, who is incapable of bearing children. These women have no marriage contract if they get married. You're not supposed to marry them. If you do marry them, she doesn't get a ketubah. So the Gemara infers, however, any other woman who can be divorced by means of a bill of divorce, and this includes a minor girl, is entitled to a ketubah, and that's why the minor girl gets the ketubah. And so the ketubah provides for her in case the husband decides to divorce her, he has to pay her big money as a marriage settlement. So the Gemara asks, and a deaf-mute woman, from where do we derive that she does not have a marriage contract? As it is taught in a baraisa, a deaf-mute and an imbecile who married halakhically competent women, and a deaf-mute woman, from where do we derive that she has no marriage contract? I think we just spelled that out. She doesn't have a contract for the purpose there shouldn't be a barrier to marry her. But maybe that's the purpose, but not the place from which we derive it. So, in a deaf-mute woman, from where do we derive that she has no marriage contract? As it was taught in a baraisa. And when we say, as it was taught in a baraisa, often we'll list several things that are taught in the baraisa before we get to the part that is the source of this law. So as it is taught in a baraisa, a deaf-mute and an imbecile who married legally competent women, even if the deaf-mute subsequently regained his senses and the imbecile regained his competence, their wives have no claim of anything against them, even if their wives receive marriage contracts from them. However, if the men wish to maintain these women as their wives after they become fully competent, then they have a marriage contract from that point onward. And in the case of a legally competent man who married a deaf-mute or an imbecile, this is the relevant part of the baraisa, and he decided to write a marriage contract for her, even if he wrote for her 100 dinars, her marriage contract is valid because he wanted to harm his own property. In other words, as he acted willingly, he's legally competent, he knows what he's doing. If he decides to provide this ketubah, it's a valid ketubah. He doesn't have to do it, but if he does it, it's valid. In other words, he acted willingly despite his lack of obligation to do so. And this is comparable to one who chooses to harm himself and give property away in any other manner. It is his choice. And the Gemara infers the reason for this law is that he wanted to write her a marriage contract. And from that, we can derive that if he does not want to write a marriage contract, his deaf-mute wife will not receive a marriage contract. So that's how we know. We saw the reason for it earlier. This is how we know that that is in fact the law. And the logic is as stated above, that if so, men would refrain from marrying her. Now the Gemara asks, if so, in a case of a legally competent woman who is married to a deaf-mute, let the sages enact a marriage contract for her. For if so, i.e., if women would not receive marriage contracts in this situation, they would refrain from marrying a deaf-mute man. If we say that we don't want to put up barriers to a deaf-mute woman finding a husband who is legally competent, well, then we wouldn't want to put up barriers for a deaf-mute man to get a wife who is legally competent. If we don't want to put up a barrier, then he should provide a marriage contract for her, because that's what she could expect from a regularly abled man, a legally competent man. So why don't we ask him to give her a marriage contract? And the Gemara answers, more than the man wants to get married, a woman wants to be married. Consequently, women will not be as discriminating with regard to marriage with a deaf-mute as a man would be with regard to a deaf-mute woman, even if the woman is not entitled to a marriage contract. Now, you could call that a very sexist statement. I wonder if people, or women in particular, would agree that women value marriage more than men do. Women understand the value of marriage more than men do. And, guys sort of stereotypically will want to extend, the young and single period, maybe more than women would want to. Until they wise up and realize how important marriage is, and women get there ahead of them in terms of that wisdom. But maybe you would disagree. The Gemara relates, there was a certain deaf-mute man who was in the neighborhood of Rav Malkiyu, and Rav Malkiyu married him to a woman, and he wrote 400 dinars for her from the property of the deaf-mute as her marriage contract, right? So that's a very big ketubah. If he decides to divorce her, he's going to owe her 400 dinars. That is like big insurance for her that this man is not going to flippantly divorce her. So Rava said, who is as wise as Rav Malkiyu, as he is a great man who found a way to achieve a desirable result by giving her a marriage contract, despite the fact that the deaf-mute was not obligated to do so. And Rav Malkiyu reasoned as follows, if the deaf-mute man wanted a maidservant to attend to him, would we not acquire one for him? This was in a time when slavery was possible. If he was a wealthy deaf-mute and he just wanted to have somebody to cook his meals, make his bed, clean the house, etc., he could purchase a slave to do that. And wouldn't he spend 400 dinars for that? Well, all the more if he could have somebody who's going to help him out and be his wife, he would be willing to spend that. So all the more so here, as there are two advantages, for she will attend to his needs and be his wife. Now, I guess it's a question that you might ask, well, if a deaf-mute doesn't have legal competence to enter into contracts, can he write that ketubah for his wife? Apparently, yes. New subject. Rachia bar Ashi said that Shmuel said, if a man had unwitting relations with the wife of a deaf-mute, i.e. not knowing that she was married, he is not obligated to bring the guilt offering for uncertainty on her account. If you commit a sin that has a heavy penalty, a kares penalty, and you do it not on purpose, unintentionally, unwittingly, and then you find out that you did it, and the temple is standing, so then you bring a sin offering, a special kind of offering, you bring it to the temple, some of it goes up on the altar, some of it is given as a gift to the priests. On the other hand, there are certain situations where you committed a transgression unwittingly, and then when you find out what you did, it's still uncertain whether you committed a transgression at all. This is called the guilt offering, and for that situation, you bring the asham talui, the guilt offering of uncertainty, because it's unclear whether or not you might have committed a sin unwittingly that would require you bring a sin offering, but you might not. And they'll explain some examples of that. He is not liable to bring an offering that is brought in cases, and in this case, he's not liable to bring the asham talui. Why? He's not liable to bring an offering that is brought in cases where one is unsure whether he committed a sin that requires a sin offering or not. A man who unwittingly has relations with a married woman must bring a sin offering. If a man had sex with a woman, he didn't know she was married. Now, he had extramarital sex, but that's not a karis penalty. Having sex with a married woman, that's adultery. That's a very heavy sin. Because he didn't do it on purpose, when he finds out that he did it, he would be liable to bring a sin offering. But here, it's uncertain whether she's a married woman or not. Why? Because she's either a deaf-mute herself or she's the wife of a deaf-mute. And, the deaf-mute is by rabbinic law. The marriage is by rabbinic law, not by Torah law. A man who unwittingly has relations with a married woman must bring a sin offering. Whereas, if the woman was doubtfully married, he brings a guilt offering for uncertainty. However, the marriage of a deaf-mute is not even categorized as a doubtful marriage. So the Gemara comments, let us say that the Mishna in Terumos 1:1 supports Shmuel's opinion. This Mishnah says, there are 5 categories of people who may not separate teruma ab initio. And if they separated teruma, their teruma is not considered teruma. And they are a deaf-mute, right? You have to have legal competence to be able to separate teruma from your produce when the temple is standing so that you can give it to a priest as consecrated food for his use. But who is not allowed to separate teruma from produce? A deaf-mute, an imbecile, a minor, and one who separates teruma from produce that is not his, and a Gentile who separated teruma from the produce of a Jew, even with the Jew's permission. That's something that if you're not going to do it yourself, you have to delegate it to another Jew. In this last case, his teruma is not considered teruma because a Gentile cannot be appointed as an agent to separate teruma, and all the more so, he cannot separate teruma on his own, right? Gentiles have no obligation to separate teruma, so if they did separate teruma, it's not teruma. And all the more so this shows that the act. So meanwhile, in passing, why do we learn this whole this Mishnah? It was to teach that this shows that the actions of a deaf-mute have no effect and are not even considered of doubtful validity. Now, we've said that there is marriage to a deaf-mute by rabbinic law in certain situations so that they can get married, but it's very limited in scope. What is the legal validity of that marriage? The one who marries the deaf-mute, and is having children with them and having sex with them is not committing a transgression. That's the value that the sages instituted marriage by rabbinic law between a legally competent person and a deaf-mute. Nonetheless, that marriage does not have full legal significance, and here it's being compared to one who is not allowed to separate teruma, who separated teruma, and that action is not a legal action. It's not valid. So the Gemara responds, but this is no proof. That you brought the wrong example, pal. This is no proof. As with regard to teruma, Shmuel said his statement in accordance with the opinion of Rabbi Elazar, as it is taught in a baraisa that Rabbi Yitzchak said in the name of Rabbi Elazar, the teruma of a deaf-mute is not released into non-sacred status because it is uncertain. If a deaf-mute separated teruma, is it teruma? Maybe yeah, maybe no. Right? So you don't give it, he doesn't, if a deaf-mute separated teruma for another Jew as his agent, so that Jew is not going to be able to give that teruma to a priest and have his obligation to separate teruma fulfilled so that produce is tithed as far as teruma is concerned. However, the teruma that the deaf-mute separated does not return to the produce pile as non-sacred produce, because the actions of a deaf-mute are of uncertain legal validity. And that seems to jibe much better with the marriage to a deaf-mute by rabbinic law. So Rabbi Elazar does not maintain that the actions of a deaf-mute have no consequence whatsoever. He says that they have uncertain consequence. So the Gemara asks, if Shmuel maintains, in accordance with the opinion of Rabbi Elazar, that a deaf-mute is competent, let him also obligate a man who has relations with the wife of a deaf-mute to bring a guilt offering for uncertainty. How can you say that he doesn't even bring the guilt offering of uncertainty? Okay, he did it not on purpose, so he's not liable to a death penalty. And we're not going to say that he for sure committed adultery, so in which case he'd be liable to bring the sin offering, but at least say that the wife of the deaf-mute, that marriage is at least of uncertain legal validity, and so he should be, if he did that unwitting transgression to have sex with her, he should be liable to bring the guilt offering of uncertainty. And the Gemara answers, we require one piece from two pieces. What does this mean? This is a cryptic statement, and it is referring to the usual case that's given to explain when the guilt offering of uncertainty is brought. And that has to do with eating non-kosher food. Like this. Shmuel maintains that one is not liable to bring a guilt offering for uncertainty in every case where there is doubt whether or not there was a transgression, and where one would be liable to bring a sin offering if it were certain that there was a transgression. It's not that just because you're uncertain whether you committed a sin that if you did it on purpose would require, would be a big transgression. If you did it unwittingly, would require the sin offering, and you're just uncertain if you did it or not. There's actually going to be different types of cases where there is an uncertainty, some of which will lead to liability to bring the asham telui, the guilt offering of uncertainty, and some of which do not. How? A guilt offering for uncertainty is brought if, for example, one had two pieces of meat before him, one of which was definitely forbidden while the other was permitted, but he does not know with certainty which one he ate. However, when the doubt involves a single item or action, which may or may not have been prohibited, in that situation, one does not bring a guilt offering for uncertainty. In the case discussed here, the doubt concerning the wife of a deaf-mute does not involve a choice between an action that is prohibited and one that is permitted. Rather, it depends on the status of the marriage, right? Like if there were two pieces of meat and you ate one, so then if you ate the wrong one, for sure you committed a transgression. And if you ate the right one, then you're good. But you definitely ate, right? So you're uncertain whether you're liable to bring it or not, but you definitely took an action that if it was the wrong one, when you ate one of those pieces, that would, if it was the wrong one, you'd have to bring a sin offering. And so in this situation, you'd bring the guilt offering of uncertainty. But where you only ate one piece and you don't know what it was, it might have been unkosher, it might not, but you don't have any but it wasn't like there was for sure an unkosher piece of meat in front of you and for sure a kosher one and you ate one of them. Rather, if there's only one piece of meat and you ate it and it possibly was non-kosher, possibly not, but there was not for sure a non-kosher piece of meat in front of you, it's a different outcome. And that's what this is likened to here. So the Gemara asks, and does Rabbi Elazar need a case involving one piece from two pieces to render one liable to bring a guilt offering for uncertainty? But isn't it taught in a baraisa that Rabbi Elazar says, with regard to a koi is a kosher animal that has characteristics of both a domesticated animal and a non-domesticated animal. Is a kosher animal. But there are different laws for eating domesticated kosher animals versus undomesticated kosher animals. So with regard to this koi, one is obligated to bring a guilt offering for uncertainty if you eat its forbidden fat, Why? Because certain fats, which are permitted in the case of a wild animal, are prohibited from a domesticated animal. They're both kosher, but if it's a wild animal, there are certain parts of the animal that are permitted, but if it was domesticated kosher animal, those parts are prohibited. And the koi, we're not sure if it's a domesticated kosher animal or an undomesticated kosher animal. We know what animal is here. It's definite. We know what happened, but we're not sure of the legal categorization of the koi. That's a different kind of uncertainty than when you ate. So you ate one piece of meat. You're not sure whether legally speaking it's kosher or unkosher. That's similar to the koi. Whereas with the two pieces of meat, one of them was definitely unkosher, the other one was definitely kosher. You're just not sure which one you ate. It's different when the uncertainty is about the legal classification versus uncertainty of what event actually happened. The Gemara answers. Shmuel holds, and so likewise here, this man, who had relations with the wife of a deafmute, for sure he had relations with her. That's not the uncertainty. The uncertainty is the legal classification of their marriage. So the Gemara answers, Shmuel holds in accordance with the opinion of Rabbi Elazar in one matter, the status of a deaf-mute, and he disagrees with him in another matter, the law of the guilt offering for uncertainty. And there are those who say a different version of the above discussion. Rabbi Chia bar Ashi said that Shmuel said, if a man had unwitting relations with the wife of a deaf-mute, he is obligated to bring the guilt offering for uncertainty on her account because of the doubt. They would obligate the man to bring the Asham Tului, the guilt offering of uncertainty, in this case, based on our uncertainty of what is the legal classification of her marriage to a deaf-mute man. Now, the Gemara raises an objection. 5 categories of people may not separate teruma, etc., in which we said that a deaf-mute who separates teruma, his teruma is not teruma. So the Gemara answers that Shmuel maintains his opinion in accordance with the opinion of Rabbi Elazar that the teruma of a deaf-mute is considered teruma that is of doubtful legal status. So Rav Ashi raised a dilemma. What is the reason for the opinion of Rabbi Elazar? One possibility is that it is obvious to him that the mind of a deaf-mute is weak, right? Is inherently legally incompetent. However, he is uncertain as to whether his mind is clear. In other words, although a deaf-mute is weaker intellectually than an average person, again, under ancient understanding, when deaf-mutes didn't have access to the kinds of sign language and other tools that we have in modern times. So although the deaf-mute is weaker intellectually than an average person, and he does not understand everything, nevertheless, he is aware of what he is doing with regard to certain undertakings. Now we're on 113b. Or perhaps his mind is not clear, i.e. he cannot achieve a full and clear understanding. And yet, he is always of one mind. In other words, a deaf-mute functions at the same level of intellectual capacity every day. So Rav Ashi explains the other possibility. Or perhaps it is obvious to Rabbi Elazar that the mind of a deaf-mute is weak and his mind is unclear, but in this case here, this is Rabbi Elazar's reasoning, since he is at times competent and at times not competent, without clarity of mind, i.e. he does not function at the same level of understanding every day, therefore the teruma of a deaf-mute is considered teruma that is of doubtful legal status, not because generally speaking of the legal classification of the deaf-mute, but rather because we're uncertain of did he understand that he was separating teruma with the full understanding of what that means at the time that he did it. We're not sure. And the Gemara asks, well, what's the practical difference? How one defines the intellectual capacity of a deaf-mute? And the Gemara answers, it makes a difference with respect to divorcing his wife with a bill of divorce. If you say that a deaf-mute has one consistent mind, his divorce is equivalent in status to his betrothal. Since he had the same mind at the time of his betrothal as at the time of the divorce, it is a legally valid divorce. But if you say that he is at times competent and at times not competent, so he may betroth the woman, as the sages are stringent and assume that he was healthy and of clear mind at the time. However, he cannot divorce her. due to the concern that he was competent when he betrothed her, but he is not competent now. If so, what is Rabbi Elazar's reasoning? No solution is found, and therefore the Gemara states that this dilemma, teku, it shall stand unresolved. New subject. The Mishnah taught that one whose wife became an imbecile, absolutely legally incompetent, may not divorce her. Right? She's incapable of understanding that he gives her a divorce. They had a full marriage by Torah law when they got married because she was competent, and then she became legally incompetent. Now, this has great practical significance if you think about a couple, God forbid, where one of the spouses, or let's say with a wife, gets dementia later in life. She is now absolutely legally not competent, and he may not divorce her by Jewish law. So Rabbi Yitzhak said, by Torah law, a woman who's an imbecile may be divorced, just as it is in the analogous case of a legally competent woman who is divorced against her will. If a legally competent woman can be divorced even though she understands what's going on, doesn't agree with it, but against her will, he can give her a get, then even if she doesn't understand it, why couldn't he just, give her the get and divorce her? That's by Torah law. Since there is no need for a woman to agree to receive a bill of divorce, the imbecile's lack of sound mind does not prevent her from being divorced. Well, if so, what is the reason that the sages decreed that the woman who becomes an imbecile may not be divorced? The reason is so that people should not treat her in the manner of ownerless property. Since she is not of sound mind and has no husband to protect her, there is concern that people might treat her in a disrespectful fashion. It's a beautiful decree from the rabbis to protect her now that she has lost her legal competence while she was married. So the Gemara inquires, what are the precise circumstances of this case? If we say that this woman knows how to guard her bill of divorce, i.e., she understands what the bill of divorce is, and she also knows how to take care of herself, would people treat her in the manner of ownerless property? She's capable of protecting herself. Rather, the Mishna is evidently referring to a woman who does not know how to guard her bill of divorce, nor does she know how to take care of herself, which seems like, well, that would be an imbecile. And the Gemara asks, is it correct that by Torah law, a woman who becomes an imbecile may be divorced? But even by Torah law, this might not be allowed. Didn't a sage of the school of Rabbi Yanai say with regard to the verse, Deuteronomy 24:3, he shall write her a bill of divorce and give it into her hand, that this refers only to a woman who has a hand, meaning she has enough intellectual capacity to accept the bill of divorce for herself. And this serves to exclude this woman who became an imbecile and who does not have the ability to accept the divorce upon herself. And the school of Rabbi Yishmael taught this a little bit differently. The verse continues in Deuteronomy 24:3, and send her out of his house. And this indicates that one may divorce only the type of woman whom he will send away and she will not return. That excludes this woman who became an imbecile, as he will send her away and she will return. She does not understand what a divorce is and she knows no other home. I'm almost done. If you have any comments or questions, get them in. So the Gemara explains, no, Rabbi Yitzchak's law is necessary in the case of a woman who knows how to guard her bill of divorce, but does not know how to take care of herself. By Torah law, this woman who became an imbecile may be divorced, as she knows how to guard the actual bill of divorce, and yet the sages said that her husband may not divorce her, so that people should not treat her in the manner of ownerless property because she does not know how to take care of herself. Abaye said the language of the Mishna is also precise in this case, as it teaches with regard to this woman that if she became an imbecile, he may not divorce her. And yet, with regard to the husband, the Mishna states that if he became an imbecile, he may never divorce her. What is different here that the Mishna teaches using the word never, and what is different there that it does not teach the word never? Rather, one may learn from here that this law, that a man who becomes an imbecile may not give a divorce, applies by Torah law, and this one, that a man may not divorce a woman who becomes an imbecile, that applies by Rabbinic law, and therefore the Mishnah does not add the phrase never. Okay, That's what I've got for us today. Let us check questions and comments. Here on page 113 in Tractate Yevamos. Sharon, what about the woman who starts out in her marriage as non-disabled and through injury or disease becomes a deaf mute? What becomes of her status? So they definitely mentioned that, one who becomes a deaf mute. Also one who emerges from being a deaf mute. So when she becomes, if she becomes an imbecile, that's what we've been talking about. And she just does not have the legal competence. Now, it's interesting. If she becomes a deaf mute, I think he can't divorce her. I'm not sure. Now I forgot. I mean, we covered so many cases. But what your point is, and it's an important one, is that she entered the marriage legally competent. So it's a marriage by Torah law. Now she becomes a deaf mute. Well, she's already married, right? So they're married. The fact that she became a deaf mute doesn't end the marriage, right? Is she able to receive the bill of divorce? Maybe yes, maybe not. So I'm not sure, but that's a good question. We covered it. I just don't remember what the outcome was there. Okay, Aoife. My observation is that women value a man to provide. How can a deaf mute provide? Right? In modern times, he certainly can. In ancient times, he could not. Right? So that was an important, very important distinction, and why it would be very difficult for a deaf mute man to find a woman, especially a legally competent woman, to be his wife. And that's why the sages didn't want to erect any further barriers to him finding a wife. And finally, okay, good. So Yosef is actually asking a kind of general principle. In general, are cases of uncertainty treated stringently or leniently, or does it depend on what for? The general principle is that in cases when we're discussing a Torah law, uncertainty is treated stringently. And in cases of a rabbinic law, which is already a fence around the Torah from keeping us from violating Torah laws, cases of uncertainty are treated leniently. That's a good general principle. Of course, there's going to be exceptions, but that is a good general principle. Okay, that's what I've got for us today. And with God's help, we'll be together again tomorrow for page 114. Have a great night.